believe we can go ahead and get started. So welcome to the jury. Today we have a very serious matter. The case is fake. The people are fake. The court is fake. But your judgment is very real. Master Oogway has been brought up on charges of fraudulently claiming to be a Galapagos tortoise. As such, there are two elements of the crime that you will need to pay attention to, and when it is time for you to come to a vote, you will need to vote not based on your own feelings, not based on your preconceived notions, but rather on the merits of the evidence presented to you by the prosecution and the defense today. Those elements are as follows. 1, that the defendant, Master Oogway, fraudulently represented himself, and 2, that the defendant's fraudulent representation was that of a Galapagos tortoise. With that being said, are there any questions of the jury as to what the criteria are for the vote? All right, we will begin. Prosecution, it's up to you for your opening statement.
Thank you, Your Honor, and honorable members of the jury, as well as the honorable members of the defense, especially the honorable bailiff Stone and the honorable judge. Today, we are bringing to trial a man who has claimed to not be as such. And I today will prove beyond a shadow of a doubt that this reign of terror, as masquerading as a terrapin or tortoise-like creature, should be stopped. And yeah, that's all I've got. I've got like a whole slideshow. So, Your Honor, when should I begin presenting evidence at this point, or?
I'd like to raise an objection.
Go ahead.
The prosecution called Master Oogway a man. This is begging the question when this is going to be the claim the prosecution is making. I would like to request that the rhetoric avoid begging the question about my client's identity, since this is a case about my client's identity.
Well, as we're seeing in Rittenhouse versus the people of Wisconsin, I find it odd that you would have such an issue with rhetoric being deployed in an opening statement, counsel. Perhaps you would like to be denied rhetoric as well in your own opening and closing statements.
It is not rhetoric itself that I'm denying. It is the question-begging rhetoric. It is not right to call Kyle Rittenhouse the murderer of that night. We cannot use language like that in a trial that is trying to decide if Rittenhouse is a murderer. In the same way, the analogy follows here. It is not right to assume Master Oogway is a man when the question is going to be about if he is a turtle or a man.
I'm fairly certain that the prosecution is going to be held to account for if what they say in their opening argument, their opening statement is true. I think we'll see that evidence, and I think it's on the jury to decide. Objection overruled. You may proceed.
Thank you, Your Honor. As many of you who have been on the server are familiar with, there is a gentleman, emphasis on man, among us, who is called or known by the name Master Oogway. Master Oogway claims, in fact, to be a tortoise, but upon further research, it will become evident that this cannot possibly be the case. The Galapagos tortoise, the species of tortoise that the defendant specifically claims to be affiliated with or to be identified as, is a very large tortoise species in the genus Caligonoidus, and they are the largest living species of tortoise. Some Galapagos tortoises weigh up to 417 kilograms. This, in itself, the mere size of this tortoise would make it nigh impossible for a tortoise to participate on Discord, as its appendages would probably be too heavy to effectively use a keyboard. I would then like to proceed to some of the evidence, but I don't want to get into evidence before the defense makes their opening statements if that's not the proper format.
We will, yes, let's go ahead and kill the stream now, and let's have you maybe give an overview of what you will be presenting when it's time for you to bring these evidentiary exhibits forward.
Absolutely, absolutely. I will establish today, through the proceedings of this court case, that there is in fact motive for Master Oogway to have falsely portrayed himself as a tortoise, and that motive was perhaps insidious in nature, and that through that motive there is also evidence and inconsistencies in his portrayal of himself that would allow us to conclude that he is falsely portraying himself for his own specific motivations.
Anything else, counsel?
No, I apologize. Am I supposed to say, should I say like the prosecution rests at the end of all my statements so that you guys, or we can know when to move forward?
We'll rest at the end of the trial. Defense, your opening statement, please.
Thank you, Your Honor. My client today, Master Oogway, is being brought up on a trial that violates his inherent sovereignty. I'm going to invoke two notions of sovereignty. One is sovereignty of identity, and the other is rhetorical sovereignty. In order for the prosecution to prove beyond a reasonable doubt that my client, one, fraudulently misrepresented himself, and two, that such a fraud was done incorrectly, identifying as a turtle, they first need to show that sovereign identity and sovereign rhetoric are in fact false. They additionally need to demonstrate the court has jurisdiction to rule in instances of such sovereignty. These three conditions need to be met beyond a reasonable doubt in order for the prosecution to succeed in their case. I will present to the jury and court my view of sovereignty and explicate on why my client is justified in his sovereign identity and rhetorical representation as a turtle. First, what do we mean by sovereignty? Sovereignty is the right of a people or person to conduct its own affairs in its own place, in its own way. The jurisdiction of the Court of Arthuria does not include issues of sovereignty. I present to the court the only written account of court jurisdiction. One moment, Your Honor. What text channel should I present this in, Your Honor?
I given that this is a serious matter, I find that saloon most appropriate.
Serious Saloon. So I have placed this in Serious Saloon. You can see from October 11th, the court said, one, jurisdiction. Arthuria has jurisdiction to handle a case for its users on trivial social matters. It does not make a claim about more serious, deep matters like sovereignty. I will continue. As this is our first trial, and since the claims do not violate any Discord rules or server rules, then the prosecution must meet a burden of proof that the court even has the right to pass the judgment. Furthermore, if they are by some miracle able to demonstrate the court's power sufficiently, they must demonstrate my client has no sovereignty over their identity or rhetoric. It is the view of the defense that such an act is an act of colonization and species domination. Since my client is a turtle, that means there is something it is like to be a turtle. Only turtles know what it is like to be a turtle. And as such, the prosecution would be unable to grasp what it is to be a turtle, given they are humans. Therefore, when the prosecution looks at Oogway and claims he is a person and not a turtle, this is actually a projection of the prosecution's inability to see anything but their own humanness and something else. The claim of my client is simple enough. Given sovereignty, it is sufficient to be a turtle if my client makes the claim with the proper authority. Since he has the proper authority, then no amount of evidence is sufficient to deny the claim. What must be denied is the sovereignty itself. This is a burden of proof the prosecution and court cannot meet. They do not have the sovereignty to impose an identity or rhetoric on my client. Otherwise, the violation of rights would be the erasure of turtle culture, species identity, and personhood. Such an erasure not only violates the principles of truth that Arthuria strives to meet, but also violates Discord community guidelines, specifically guideline number 17. I quote, You may not share content that violates anyone's intellectual property or other rights. The denial of sovereign identity and rhetoric violates both intellectual property and other rights. And as such, this entire case violates Discord community guidelines. So let me summarize for the jury my claims. 1, my client has sovereignty over his identity and rhetoric. 2, the court does not have sovereignty over users' identity or rhetoric. 3, the prosecution must demonstrate the negation of my client's sovereignty and the affirmation of the court's authority. 4, the claims themselves violate the legal framework of this app, namely violating guideline number 17. It is sharing content that violates my client's intellectual property and other rights. 5, if Oogway were a turtle, the prosecution would be unable to see it. Or if he is a turtle, that would mean there is something it is like to be a turtle. Only turtles can know what that is like, and so the prosecution, being humans, are unable to grasp what it means to be a turtle. And so they would be projecting their humanness onto that understanding. This is a form of species domination and human colonization. 6, they simply have no case. I rest my opening statements.
Your Honor, I would like to submit an objection.
On what grounds?
On the grounds that the defense has claimed to know my identity. I have not proclaimed any particular identity. So for the defense to claim that my identity is that of human and that I am therefore imposing humanness onto his client is improper, as there has been no proof or evidence to suggest that I am in fact human. For all the defense knows, I could in fact be accurately portraying myself as a turtle.
May I respond, Your Honor?
Yes.
So, it is reasonable to assume humanness given the evidence presented in the discovery period. The prosecution is relying on an argument that only a human could use Discord. Only a human is able to have this kind of conversation. It is implicit in their very argument in the first place that they are human. If they are not human, then their entire case falls apart in contradiction.
Well, I have two responses to this objection before it's overruled. First, the relevance of arguing with the judge is, well, there is none. You are here to present your case to the jury, not to me. The second note, and this is for the defense, is a procedural note. I don't think it's appropriate for the jury to determine jurisdiction in this case. These matters were settled in pretrial, such that bringing up the jurisdiction note is not relevant. However,
Your Honor, may I interject there? I am not claiming the jury is deciding the jurisdiction. I am claiming the prosecution must demonstrate the jurisdiction, not the jury deciding.
This matter was settled pre-trial. However, I do find that the rest of your points stand as reasonable for the jury to proceed. However, you're putting me in a pickle there, counsel.
This is a standard in many legal court systems when there is no precedent. The precedent is decided in the trial itself. It seems to me like it would be sympathetic to many Western legal systems around the world.
Yes, the prosecution is free to respond and establish matters of jurisdiction prior to proceeding with other presentations of evidence, unless this is already factored in by the prosecution's argument or further evidence that they will be submitting. Are you able to roll with that?
Yes, Your Honor. I do believe that I coincidentally will be able to prove that, in fact, the court ought to have jurisdiction in this particular matter of sovereignty, as it represents a risk to those who are involved in this particular server, as the intents and actions of the defendant's client represent a danger of security and safety for those of us who participate regularly on this server. And in that particular instance, I do believe that the jurisdiction of the court would necessarily require that the defendant accurately portray themselves.
The court is inclined to agree that it has jurisdiction over its own matters. But let's go ahead and proceed with the prosecution's introductions into evidence and calling witnesses.
Thank you, Your Honor. As the jury may now join the stream to observe the presentation of evidence that I am going to go through in order to establish motive. I am not sure of the format that is preferred by the court, whether or not they would like to pause after each presentation of evidence via slide, or if they would like me to just simply continue through until the defense has a statement they would like to make regarding the evidence.
You may proceed. However, if the defense objects, and I'll get to your point of order in a moment, if the defense has an objection, do not proceed with further evidence until the objection is resolved. In your point of order?
Thank you, Your Honor. I agree with the court's decision about the procedures of evidence. I would just like to make it clear that if the jury has any questions, I'm amenable to them asking for a pause or a repetition of the evidence in some way to clarify. I'm open to that discourse.
The evidence needs to be presented in such a way after the presentation such that the jury may review it. Are you able to provide a link to this document for the jury there, counsel?
Absolutely. Give me just a moment here.
You can do it. You can do it after.
That way, not everybody gets my email address. Doxing myself.
Also unwise,
right, Your Honor.
All right, you may proceed.
Thank you, Your Honor. So this first presentation of evidence is to just kind of establish what it is that would be necessarily defined as an individual that identifies within the human species. I have included a couple of small snippets of dialogue of Oogway that suggest his malicious intent, as we will go through that particular aspect of his motivation later. But the first portions of the evidence are to suggest that it is in fact impossible for Oogway, through the way that Oogway has portrayed himself, to be considered to be a turtle or a tortoise. And I would also like to make note of this particular statement at the bottom, in which Oogway says, "I fail to see why not. My assumption that only I am sentient has far less additions than me saying I am sentient and humans other than me are." That in itself is an admonition of his humanhood, and I would like to submit that as a particular piece of evidence. I would next like to move into some different available options.
May I make a point of order about one of those statements?
Well, the prosecution gets to present their evidence. However, if you object to any of these statements or you need to call any of this evidence into question, you are free to reference that during your arguments.
I see. My apologies. Continue.
On this next slide, we can see that, in fact, there is the anatomy of a tortoise and then the most well-known locations of Galapagos tortoises. Galapagos tortoises, as we mentioned earlier, are an endangered species that is indigenous to the islands of Galapagos. There are several different varieties. Oogway claims to be the particular variety that is portrayed in the movie Kung Fu Panda. I believe that is the Santa Cruz variety of Galapagos tortoise. I have included the anatomy of the tortoise in hopes that during the examination of my witness Oogway, assuming that he decides to show up to his own trial, would be able to answer questions about his anatomy at his own discretion, as I know that privacy is a right that is afforded to him. I did also want to make mention of the fact that there is in fact an indigenous tortoise to Croatia, but it is not the tortoise that Oogway claims for himself to be, and therefore if you were able to look up and search for any indigenous species in Croatia or the likelihood of any particular kinds of tortoises being in Croatia, what is it called? Sorry, Your Honor. I guess I didn't include the name of the tortoise. The indigenous species is the most likely species that Oogway would be, as it is very financially difficult to acquire or to move a tortoise, and for it to move of its own volition throughout the world would be nonsensical. I have also, on the next slide, included several depictions of fictional tortoises, as I would like to address the fact that Potentially, the defense intends to portray himself as a fictional tortoise and therefore be tortoise in metaphor and not in actual identity. But I will submit that in fact it is impossible for him to meet the criteria of being a fictional tortoise. As you can see from this slide, there are several different occurrences of tortoises in fiction, in our modern fiction as well as in fables. All of these tortoises exhibit patience, kindness, altruism, and a particular level of intelligence. Or they are beholden to a master, as you can see from the My Little Pony picture. The tortoise Tank is the pet of one of the My Little Ponies. And then I have included a picture of Mitch McConnell, as he's clearly a tortoise that has been given a human skin and is operating as a bot in the simulation. And I would argue that that Master Oogway does in fact not exhibit enough characteristics of being an incumbent slime bag of a politician to also fit into that particular criteria of tortoise. One specific fictional depiction of tortoise that I thought was worthy of note is the depiction of the tortoise and Achilles. This is a fable written by Lewis Carroll. In this fable, Achilles, a character, I'm not sure if it's the Greek hero Achilles or if it's just someone named Achilles. I apologize to the jury for that. But they have a discussion regarding the regressive problem that occurs from modus ponens deductions. The reason that I wanted to bring up this specifically is because I thought it might be an example in which the defense might be able to claim that Oogway is in fact a tortoise because he exhibits the characteristics of this particular fictional tortoise and therefore could be considered to be a fictional tortoise. But it is in fact the case that, as you can see on this particular slide of evidence, that Oogway does accept the conditions of modus ponens frequently and uses deductive logic in a fashion that would suggest that he cannot align himself properly with the beliefs of the tortoise in the Achilles and the tortoise situation. As you can see here, he is looking at if, therefore, statements, which would be the conditions of modus ponens or some of the conditions of modus ponens. At this point, I would like to move into the evidence that suggests motive if the defense has no questions or the jury has no further questions regarding this particular bit of evidence.
The defense has no questions.
In this slide, titled What Makes the Fake Galapagos Round, I am going to establish the motive that Oogway has to portray himself as a tortoise. As you can see from these miscellaneous interactions on our server, Oogway often makes statements that slander the administrator of our wonderful server here, the Honorable Bailiff Stone. He calls him a bitch multiple times here. And he has also clearly has not read the contract for being a moderator on this particular server. And you can see here, he has also found deleting messages. This particular message was deleted after his charges were created. So it is clear here that there is some sort of insidious intent. There is also an example of Oogway potentially overstepping bounds with another user of our server and stating that humans are, in fact, disposable. These kinds of statements would normally solicit a very negative reaction. But as long as individuals believe that Master Oogway is a tortoise, they have no reason to attempt to bring him to count for his transgressions or gross statements. But why, aside from, exemption from typical social interactions, would Oogway wish to portray himself as a tortoise? I would submit here that there is a motivation or a clear and present motive that Oogway has attempted to portray himself as being some sort of turtle god and wishes to establish himself as being the leader of a cult in an attempt to overthrow Stone and to take over the server. Hence why the jurisdiction of the court would necessarily require that it holds him to count and establishes that he is, in fact, human. In addition to that, as you can see from this particular bit of evidence down here, where Oogway claims to be a fruitcake, it is clear and apparent that the defense is motivated to portray themselves in whatever identity is most beneficial for them in those particular interactions. As when he wants to be a fruitcake, he can be a fruitcake, but he also claims to be fluid. And I do not believe that tortoises or turtles are necessarily fluid. In addition, you can see him attempting to use his authority here improperly to ban a statement made by the user Roddy that turtles are Nazis in disguise. And I do believe that this is just yet another example of motives that would necessarily require not necessarily require, motives that would establish that the defense is using the identity as a turtle in order to solicit followers and solicit enough power to overturn Stone as the server administrator and take over Arthuria and potentially even the world with his cult of turtle worship. This is further evidenced by the suggestion that Oogway has included himself in a picture and is trying to establish an online presence of his influence over the rest of the internet. You can also see more examples of Oogway attempting to portray himself in a way that would solicit worship or following from other users, and yet another statement in which Oogway has claimed or has clearly shown that he is willing to commit actions that would not draw a turtle into account, but would in fact draw a human into account. And in using the identity of a tortoise or a turtle, he is in fact attempting to obfuscate himself from justice. These are more slides of examples of that particular behavior. Here's an example of him accepting the claim that he is a wise turtle. And again, another claim that he is in fact the coolest turtle. A statement that he has always been truthful, which is in fact impossible for any organism, let alone a tortoise, to be consistent, as well as a personal recounting of a transformational experience in the mountains in which he claims to have become a turtle. At this point, the prosecution would like to move into the claims that the defendant makes in regards to actually being a turtle, which, as is mentioned before, he in fact claims that he is many things, and if he claims to be a turtle, then he ought to always be consistent with those claims. Here he is claimed to be a Galapagos tortoise. Here he is claimed to be a tortoise or turtle that is herding. As we can see from Alex the Dank Engine, all tortoises are turtles, but not all turtles are tortoises. This can be corroborated by further statements from witnesses. And then this particular instance, I think I might be mentally deficient, is an attempt for Oogway to post a picture of himself, which was in fact a GIF, which I would argue, if it was an actual GIF of him humping a Croc shoe, that it in fact would be lewd content and would in itself be worthy of disciplinary action. But because he is falsely claiming to be this, he is simply attempting to explain some sort of weird fetish that he has for Crocs and is deferring the otherwise social rejection that he would experience by claiming that he is in fact a tortoise and not a human who simply has a weird, I apologize, that's weighted language, who simply has an affinity for humping shoes, specifically those of the Croc designation. Here are more examples of him claiming to be a turtle, as well as a master of Kung Fu, which there is no evidence to suggest that he can, in fact, confirm that. These are some of the claims that the defendant has made in regards to personal behavior and other things that they enjoy. In this particular statement, Oogway is said to have run away from beetles, but I do not understand why anything or anyone or any particular instance of a turtle would run away from that which it normally eats. Even if it was full, it would probably feel that it was benign. I would also like to mention that he specifically references liking cat costumes, but the cat is a naturally occurring predator to turtles and tortoises. And then in this particular statement, he claims that he is very forgetful, but as you can see from the University of Lincoln, it is in fact found that tortoises do possess quite strong long-term memory capabilities, so it would not be the case that they would forget this particular thing and fall for it again. And lastly, Your Honor, these are some reiteration of that first statement where he says, I am sentient and humans other than me, as in I am human and humans other than me are in fact sentient, would be a statement of the defendant's humanness. And then also again reiterating the statement here that he is willing to use whatever identity most benefits him in particular interactions, as well as another insult to our honorable bailiff Stone that kind of just reaffirms the motive that in fact Oogway is looking to undermine Stone in an attempt to take over Arthuria and eventually perhaps other things as well. This concludes my presentation of evidence.
All right. Call your first witness.
Yes, my first witness had intended to be Oogway. I do apologize. It seems that he is absent from his own court proceedings. We
Well,
do,
he is being
however,
held in contempt, as we discussed, and contempt is not in the courtroom. Contempt is typically a place far away in the deepest pits of the closest jail cell I can find.
Yes, Your
So
Honor.
unless his um, unless counsel plans on something else for him other than invoking the Fifth Amendment, I'm sure that I'm relatively confident that counsel would not um, uh, allow their client to take the stand. Uh, but I don't want to speak out for the defense if this is inaccurate.
Your Honor, we would appeal to the court's ruling in this case. If the court deemed it necessary for his witness to be part of the trial, we would appeal to the Fifth Amendment. But otherwise, it seems the contempt is sufficient.
All right, prosecutor, are you comfortable with skipping past the pleasantries of Oogway's every response being I'm exercising my right to not incriminate myself, and just kind of getting through this and moving on to your next witness?
No, Your Honor, I have no objections to that. The first bit of evidence that I would like to present was a piece of evidence corroborated, or a statement, an evidence or a witness statement that has been listed in the Sirius Saloon by Brock, who username Frozen Broccoli, who is in fact an expert in the field of biology, and states that
Prosecution objection potentially. Was this submitted in the trial evidence in the discovery period?
What was the time of this submission, counsel?
This was not.
I
I have not seen this evidence until now.
That's a question for the prosecutor. I should be clear.
Yeah, Your Honor, I apologize. I was not aware that a written witness testimony counted as evidence that was needed for the discovery period. I believed that it was something that was allowed to be presented during the trial.
Yes, that's fine. That's fine.
We do. I am checking the record, and I do see that Frozen Broccoli was on the witness list. This was marked in the trial evidence thread, October 31st at 6:04 p.m. Pacific time. So the affidavit from Frozen Broccoli stands.
Thank you, Your Honor. And
am I allowed to cross-examine the witness based on that testimony?
Yes. And as this was originally designed to be a witness. However, this was circumvented due to possible time considerations. If that witness is in court today, they may be cross-examined.
Thanks, Your Honor. Proceed, prosecution.
Thank you. According to, or picking up where I left off, I find it impossible for any species of tortoise to be a participant of a Discord server. Their morphology alone would make it impossible for them to participate in written chat, let alone in spoken chat. Similarly, they also do not possess the ability to produce human-like speech or language. I therefore find it impossible for any of the defendant's claims of tortoisehood to hold any ground, and believe it. He ought to be held accountable for his numerous transgressions, as it would be impossible, in my professional opinion, for him to be anything other than a deranged or identity-confused human. And this is pertinent specifically to the literal interpretation of the defendant being tortoise, as was addressed earlier in pieces of evidence. I also found it impossible for the defendant to make any claims that they meet the criteria necessary to be defined as a metaphorical or fictional portrayal of a tortoise.
All right. Did you have further questions of the witness, or anything further to present from the witness, prosecutor?
I do not believe so. I was told by the witness that while they may be in attendance, they would not be available to give live testimony, as they are currently dealing with family matters.
Prosecution, are you able to answer questions about this expert affidavit?
Yes, I do believe that I am qualified to do so. I've done a large amount of research, and I have also conversed heavily with the individual who gave the statements.
Thank you. I have some questions about this testimony. For example, what does deranged mean in this context? Deranged is not a clinical term for psychological states. It seems to me to be a more normative term. Can you unpack what that means for the jury? I feel that this begs the question to say that my client is crazy, deranged, psychopathic.
Yes, Your Honor. Though, however, I guess I would suppose I don't necessarily think that this is a question that I ought to answer, because in asking me to define what deranged means, I feel that it is an admission on the defense's part that their client is in fact human and is deranged.
That is not an admission, as animals can suffer from psychological conditions like depression, grief. They can have hallucinations, etc. That is not a correct implication. I'm simply asking the prosecution to expand on what deranged means for clarity.
I don't have a clear legal definition of deranged, nor am I a psychologist who perhaps may have the tools to articulate what is meant by deranged. I do agree with the defense that this question stands. We need clarity on what it means to be deranged.
Yes. I suppose that the word deranged in this particular instance was being used colloquially and was not necessarily being referred to in like a legalistic sense. Colloquially, I believe that deranged, we could simply Google the definition of that particular word, which is what I'm going to do right now. Which would be mad or insane. Insanity is, in fact, a legalese term, a bit of legal jargon. So I believe that the witness statement would be amenable to changing that particular word to insane, and would therefore be, I suppose, usable within this particular court.
I would hope that they don't change their signed affidavit at this point in time, counsel.
I just believe that they would be willing to accept an equivocation between the two words, Your Honor. Not that they would change their statement, just that in the interest of allowing the proceeding or allowing the case to proceed, they would be willing to equivocate deranged with the word insane for the sake of legal jargon.
Right.
If we grant that the word means insane, is this witness qualified to judge the sanity, given they are a biologist and not a psychologist? Did they do a cross-examination of the turtle? Did they have an expert come in and examine the turtle?
Do not believe that that is the case in this particular instance. I am willing to strike some of the witness account, I suppose, of the witness statement in favor of retaining only the statements that are pertinent to the fact that the defendant could, in fact, not be a tortoise.
Well, unfortunately, counsel, the witness's statement has been submitted into evidence at your own request. As such, no, I'm not going to strike your own evidence that you asked this court to submit. Defense, you may proceed with your questioning.
Thank you, Your Honor. Given that this expert is not an expert in psychology, I ask the jury to not consider their claims about my client's psychological states. Furthermore, this also applies to identity confused, as that is a psychological matter, unless the prosecution can unpack identity confused in such a way that it would be a biological matter and not a psychological matter. Do you have evidence of that, or perhaps an argument that identity confused is biological and not psychological?
Give me just a moment here. I'm familiarizing myself with the argument.
TikTok.
Are you referring? Yeah, to the defense. Are you referring to the state in which an individual establishes their identity within the world, as referred to miscellaneous psychological papers?
By identity, I just take it that this is what one person experiences as who they are and what they utter and claim to be. And so to claim that one is identity confused would be to say that they do not know who they are. The only person who is an expert in who they are is the individual themselves. And so the claim being put on the table is my client is identity confused. What evidence do you have that my client does not know their own identity when they are the expert in their own identity?
That is, in fact, an argument that I do not believe is surmountable. My argument in return would be that the defense or the client is using the guise of identity confusion in order to, again, disassociate themselves from the consequences of their actions.
I think we've heard enough on this note of evidence. Defense, any closing questions here as we attempt to cross-examine a document?
Yes. My other question is, by invoking biology and the possibility or impossibility of a species of being to behave in one way or another, it seems to me that this is invoking something like species essentialism. And so I would like to ask what argument the prosecution has for species essentialism or biological essentialism such that identity would not be separate from it. It seems to me the entire case rests on this, given the other evidence presented, and this expert witness would be to support such evidence. So this also relates to earlier claims of the evidence. I would like an argument for biological essentialism as it relates to identity. This, to me, is necessary for the prosecution.
The defense, please clarify what it means by species essentialism.
That there is some essence shared by all members of a species, and that any member of that species that is outside of the normal behavior would fail to meet that species anymore.
Could you repeat that one more time for me, please?
That there is some essential element that is universal to all members of the species, and if a member or a presumable member did not behave in the same way to demonstrate those essential features, it would no longer count as a member of that species.
So we're not using the defense isn't using the biological argument that a species is defined as individuals that can breed with other members of its species.
As I understand it in biology, there are several species that are distinct that are able to breed with each other.
Yes, but those are the exceptions to the rule, not necessarily what establishes the rule in the first place.
Right. So given that you've mentioned that would be one of the criteria for species and there are exceptions, it seems to me like it should not be counted as a criteria. There must be other contributing factors. And this is not even related to the question. The question is, how does biology relate to identity? You are using biology here to say they are identity confused. What is the argument that biology demonstrates the identity?
I did, in fact, not claim that they were identity confused. So that has been your presentation of your particular spin on the evidence.
That was your evidence submitted by the prosecution counts as your argument. Yes or no?
I'm going to call for order in the court here. I think the jury understands this argument at this point in time from both of you. I don't see further value in the court's precious time to continue on this note. I think we should have the prosecution call their next witness.
Your Honor, I apologize. It seems, we do have a witness here. I apologize. I had listed several witnesses and most of them did not actually show up, which is unfortunate. We should have subpoenaed them. The next witness that I'd like to call to the stand is in fact, the Honorable Bailiff Stone.
Okay. Good afternoon, everybody.
Stone, given I would normally have you do this as a bailiff, but do you swear to tell the truth, the whole truth, and nothing but the truth, so help you, Tropical Shadow?
I swear, Your Honor.
All right. Witness has been sworn in. Prosecution, you may proceed.
Stone, the prosecution has presented evidence that suggests Oogway is in fact attempting to use the misidentification of themselves as a tortoise or turtle to obscure their malicious intents of taking over the server. Do you feel, or have you felt at any point in time, that Oogway has wished to supersede you as administrator of this server?
I would say yes.
And do you feel that in those particular instances of those actions and those interactions where you were being undermined as the administrator of the server and he was attempting to supersede you in that role, do you feel that he is attempting to obfuscate his intentions behind the identity of being a tortoise or a fruitcake?
Yes, I would say so, and not just in this server, but also in Aurora.
Thank you, Stone. I don't have any further questions at this particular time.
Your Honor, may I approach the witness?
You may. Prosecution, no further questions?
Not at this particular juncture, Your Honor.
Well, once you're done examining the witness, then it's the defense's turn, and then the witness is done.
Oh, there's no rebuttal afterwards.
There is no rebuttal. No, sir.
Mm.
Is there anything else you want to establish with this witness?
Yes, I suppose I would want to just ask straightforwardly. Do you feel that the defendant is in fact false in his claims of being a turtle or tortoise?
Objection. Relevance.
Um,
What is the relevance of the bailiff's opinion about this matter on the identity of my turtle?
Objection sustained. Counsel, rephrase or ask a different question.
Apologize,
Counsel?
I'm thinking, Your Honor. Yeah, I'm here. I'm just thinking how to rephrase this question in a more pertinent way, I suppose.
If you are asking a question that calls for speculation or calls for irrelevant information, I will sustain that objection from the defense every time. And likewise for you, if the defense commits to the same issue. So I would perhaps a different line of questioning is in order. It's a friendly bit of advice from the bench.
Stone, do you believe that the evidence that has been presented corroborates the fact that the defendant has in fact misused or has used the identity of tortoise to their own benefit in order to garner followers and gain power in this server and in other places?
The evidence seems consistent with the hypothesis. So yes.
Do you... no, that's a believe question. Yeah, I guess that's all the questions I have, Your Honor. I apologize.
Defense, it's your witness.
Thank you, Your Honor. And thank you, Honorable Stone, for being at this trial today.
My pleasure.
So just a few questions. And I'm going to be asking you questions not just about your relationship with Master Oogway, but also some questions about the server, given you are an expert in both. The first question is related to something mentioned earlier about my client's identity, claiming he's a turtle or a fruitcake. I believe you responded something like it was consistent that he is not a fruitcake, etc. Let me ask you a question. When you hear the phrase "spill the beans," what does that mean to you?
Give up the gossip or give up a dirty secret.
Yeah, exactly, right. So not literally spilling beans, but it's picking out gossip or a dirty secret. Now, are you familiar with the phrase like, "Oh, this person's a fruitcake"?
Yes.
When you hear that phrase, how do you take that meaning? Do you think that they're saying they are a literal fruitcake, or do you think they're saying something else?
Well, I would say it's contextual, but I would say in most cases it probably means like they're not literally a fruitcake. They probably mean some kind of meaning like this person's a softie or something.
Exactly. Yes, there's multiple meanings. Thank you, Stone. I agree with you when I hear the term fruitcake. And so when Master Oogway said, "I am a fruitcake," in that context, do you believe
Objection,
Master
Your Honor.
Oogway?
On what grounds?
On the grounds that in the evidence that was submitted, the Master Oogway says, "I, however, am quite literally a fruitcake."
The evidence that has been submitted is not what's being examined right now, counsel. Your witness is what's being examined. Overruled.
I will
The
phrase.
word literal was used. Literally a fruitcake. There's no room for misinterpretation in that statement, Your Honor.
Prosecution. This is my
This
cross-examination.
is not your time to argue, counsel. Defense, you may proceed.
Out of charitability, I will address the use of literally here. So first, Stone, when someone says, "I am literally X," or, for example, have you watched the TV show Parks and Recreation?
I haven't.
Well, when someone utters the phrase literally, does it always mean literally? Or are there some contexts where it is ironically used in your experience?
If the question is it possible that when somebody says literally, they don't actually mean literally, then yeah, I would say a situation like that is possible.
Great. And so if someone were to say to you, "I'm a bit of a fruitcake," without literally, what would you take them to mean in such a situation?
Without the use of the word literally, then I would take it to not be literally.
And what would you take the fruitcake to be referring to?
Like a question of character.
Wonderful. I have the same meaning. I imagine many members of the jury have a similar take there. Now, if someone were to say to you, "I am literally a fruitcake," in that context, do you think that they are referring to literally being a different type of existence, or do you think that literally would be a type of amplifier, an emotional amplifier? To say, "I am very, very much like a fruitcake."
Well, I would say that the context also matters, like the prior messages and, who they're talking to, like exactly like what led the conversation to that point. So I will say that I think that matters, but in a vacuum, like in the example you provided, I would say they probably don't mean it like they're literally existing as a fruitcake.
Thank you, Stone. A few other questions. This has to do with the contract. So we do have on the record that my client said, "I haven't even read, there's a whole ass contract, I haven't read it, don't tell Stone." Now, whenever Master Oogway was asked to be part of the staff team, can you share with the jury the process of onboarding a staff member?
Sure thing. So typically we will observe a user who's pretty active on Arthuria, and we'll see how they engage with other users, how they handle stressful situations, and if we feel that they are compatible with enforcing the system that we have on Arthuria, some of us will reach out to them, like one or more, and we'll send them a staff document just listing the entailments and responsibilities that a staff member has on Arthuria. And the expectation is that they read this contract and accept the contract before becoming an official staff member.
Great. When you talk to them about moderator responsibilities, do you go through all the pertinent information that would be listed on the contract?
Just a clarification, is the question, do I sit there and systematically go through every piece of information in the document with them?
No, just that you cover all the relevant duties that they would be required, such that had they not read the contract, they could still perform moderator duties successfully.
Okay. So you're asking me, is reading through the staff document necessary for someone on the staff team to perform moderation duties successfully?
With the addition of your explanation to them about the duties being part of why they would be able to be a good mod. Basically, the question is, are they given the relevant information without the contract such that the contract is a helpful tool and not a requirement?
Okay, I understand. Yeah, I could see a possible situation where someone is a good mod and like the requirement, like the document wasn't required, neither was my my like helpful advice or like my discussion with them. I could see it a possibility that they could still succeed as a good moderator without my my advice or the document, if that answers your question.
It does. Thank you, Stone. And a final question about the contract. When you tell them about the contract, what language do you use to talk about the expectations for reading it, if you can recall? And specifically in Master Oogway's case, what language should you use? For example, it could be something like, please read this in 24 hours, sign it and get it back to me. Or did you say something more like, take your time, read it when you have the time. We already think you're going to be a great mod. This is just an outline of all the duties, etc.
So I'll say typically I just say read through it, take as much time as you need. Like, in other words, just pick a convenient time to go through the document. And whenever it's convenient for you, just get back to me. But if you'd like, if it's helpful to the court, I can take a second to go to the DMs and just read out the language that I used when sending him the document.
I don't think it's necessary. I'm open to hearing from the prosecution here if they would like it read out to the court, but from my end, it seems sufficient.
Understood.
And so the last question has to do with the server takeover. Do you think that Master Oogway is a humorous guy?
On occasion.
And I just want to be clear to the jury, when I say guy, I'm just referring to an individual you interact with. I'm not talking about Master Oogway being a man. I would refer to dogs as guys, etc. So, on occasion, Master Oogway is humorous. Do you think that part of Master Oogway's humor is to be a bit absurd?
Yeah, I would say sometimes his humor can contain absurdity.
Do you feel secure as the leader on the server, such that there's no threat from Master Oogway taking over?
By threat, do you mean possibility, or do you mean like threat as in there's a good chance that he's going to take over?
The latter.
Okay, yeah. If we just are using threat as in like there's a good probable chance as you to take over, then no, I don't feel that way.
Great. So given the context that there is no plausible threat for Oogway to take over, and that he is a humorous turtle, and that some of his humor can be quite absurd, is it plausible that his claim that he's starting a cult to take over the server, given you are quite secure as the server leader, is a joke that is absurd because there's no possibility of that actually happening?
Well, if I understood you correctly, I think it is possible that it can happen. I just don't think that it's probable that he'll succeed.
Right, yes. So do you think that Master Oogway was joking when he made that statement?
I think he was being a bit sincere, but I think he was joking about the execution, if that's an okay answer.
As in sincere in the sense of you think he genuinely would like to take over. Is that what you mean?
Yeah, I think there's like a kernel of sincerity to taking over the server in a way that would involve like more turtle aesthetics, not trying to be silly, just trying to be truthful, and say that I think he would like to make the server.
Your Honor.
Good.
Yeah.
Speculation.
Can you object to a witness testimony?
I think he can absolutely object to you calling for the witness to speculate on Oogway's sincerity. Objection sustained. The jury will strike that question, and the answer thus far.
Point of order. This is the prosecution's witness.
Yes, and it is your
prosecution
question.
brought up the point of sincerity.
Yes, but the rules of evidence, the rules of evidence apply, counsel, regardless of one's failure to or successful objection. It's irrelevant if you don't call for the objection. I have to allow things to continue in such a way. If he does call for the objection, and it is the case that it violates the rules of evidence in the eyes of the judge, which in this case it does, then yes, the objection will be sustained and we'll need to ask a different question. There's no other way for this court to proceed, counsel. If you have a different question, you can ask it.
Stone, what did you mean by sincere other than kernel of truth?
That I think he would like to see a possible situation where he's ruling over the server and the server is more appealing to like a reptile turtle aesthetic theme. But what I mean is, the other part of it is that practically I don't think he sincerely means it practically. Like I don't think he actually has the sincere belief that he can execute a plan like that.
Great. And if he doesn't have a sincere belief, do you think that it is more plausible that it is a joke or not?
That's a tough one. I think it's possible it's a joke, and I'm trying to be just very honest. I think that all right, here's my answer. So I think that in the present moment, he sees it as a joke because he doesn't see it as practical. But that's not to say that there isn't a build-up to where he's trying to get to a world where it's practical. So for now, I think he sees it as a joke because he just doesn't see it as executable at the present moment.
Great. Thank you for your answers, Stone. I just want to make a point of clarity to the jury there that, and also to you, Stone, you're saying current context, more likely a joke, that doesn't rule out the possibility of a future state where it becomes real, correct?
In execution, yes.
Okay, great. That's all I mean to point out here, that my client was joking. He is a jokester. I also would like to point, well, this is cross-examination. Let's move to the next witness.
All right, any further witnesses? Coco, any further witnesses to bring to the stand?
Not at this time, Your Honor.
All right. With that being said, defense, you may submit evidence, bring your first witness, however you'd like to proceed here.
Is this also
in your court?
Is this also the portion of the trial where I can refer to prosecution's evidence?
No. Well, yes, you can. When you're cross-examining witnesses, you can also, you can examine their evidence in depth right now.
Okay,
so you're free to proceed.
Thank you. The first thing I would like to point out is in contradiction with the motive being that Master Oogway is taking over and harming others. And so the piece of evidence I would like to show is that in order for him to be harming the server, he would need to not be doing a good job as a mod. And so I cite this evidence. I will post it in Serious Saloon.
And actually, before you begin, and I apologize terribly, counsel. For the prosecution, have you provided the jury with your document here, with all your evidence and the presentation? Has that been provided for the jury?
I have not yet, Your Honor. I would also like to present an objection that the any evidence that the defense presents has not been made or not been given, or I haven't been given access to it prior.
It was put in the evidence channel. I'm only pulling things from the evidence channel.
The all evidence in the Oogway trial evidence thread is admissible, unless some alternative objection can be raised to a particular piece of evidence. So with that being said, that objection is overruled. Both of you had time frames. We had extended these time frames numerous times to include more evidence so that we could have a robust trial here evaluating Oogway's status as a turtle and if this was a fraudulent representation or not. With that being said, if it is in this channel, which I do see that you have permissions on or for, Coco, I don't think that there's grounds to say that this evidence has not been made available to you. So defense is free to proceed as far as I'm concerned, as far as this court is concerned.
Ready to respond? Yeah, absolutely. Go ahead. Continue, I guess. Will you please, since it wasn't made, I apologize. I don't know how to phrase this exactly. The evidence that the defense would be using was not made clear based off of what was in the thread. So if you are citing a particular piece of evidence from the thread, could you please include it in the Serious Saloon chat so that I can look at it as well?
Yes, he will need to present it. He will need to present it to the jury. That is clear. So as he presents it, you will have access as well, counsel. You will continue to have access as you have had, and we can go ahead and get moving off of this point. Defense, you may proceed. Arco.
Your Honor, there's a clerical error. I did not serve it in the right area, so I'm not allowed to share it. So I'm
no. If it was okay, then
it was in the defense trial channel. I did not say it. I did not share it in the trial evidence, so it's not admissible.
Okay. Yeah,
unless it's something that I could share with the court and with prosecution now before we present it to trial.
You can make the arguments for presenting evidence now. The prosecution, however, does have the ability to object to evidence entering the court, in which case the bailiff will delete the evidence if the objection from the prosecutor is sustained.
So this is the evidence. I posted it in Oogway trial evidence. If the judge and counsel could look at that, please.
Prosecution, do you have any objections? We'll treat this as though you're approaching the bench. Do we have any objections to this piece entering?
To be a sleazy lawyer, yes, I do object to this particular bit of evidence, as it was not presented to me in advance.
Okay, on the grounds that it was not presented to you in advance,
we'll honor the court's decision.
It would have reshaped the arguments that I made in regards to my particular approach to the prosecution, Your Honor. That is why I believe that it ought to be not allowed to be included in the record. As had I known the line of which the defense was going to take, I would have altered the way in which I presented my own evidence. This would change the manner in which the court would have proceeded.
You are, of course, able to impeach a document. However, I think in this case, this is a particularly innocuous piece of evidence. I do find it relevant for the trial. It was originally suggested to be in evidence, however, was not. The only other consideration I'm weighing here is, frankly, in the spirit of the court, if while defense did fail to provide this to the prosecution, it does appear prima facie clear what this presents. Is there an objection to the content on the grounds of it being best evidence? For instance, that this document from the defense does not meet some procedural standard, or this is not how a normal record is kept, or where this is the weakest source of justifying the claims made in this piece of evidence. Is there any objection on those grounds?
Fortunately, I do not believe so, Your Honor.
Okay. So, with that being said, I'm going to go ahead and allow this piece. You may present it to the jury.
Thank you very much, Your Honor and counsel, for your charitability. I present this evidence. This is something granted by the court's permission. This took place, just to give some context, this took place in an administrative channel. So the jury is not privy to this information. It is confidential information. I just want to point out the date, October 15, 2021. This is
Your Honor.
What can you possibly object to this time, counsel?
Referencing specific information that comes from a place that which I would not have had access to draw evidence from. I believe this gives the defense an unfair advantage in pursuing evidence to defend their claim, and also an unfair advantage in the sense that I would not be able to draw evidence from the same source.
You are able to draw evidence if you requested a subpoena.
Yeah, as the prosecutor, I don't know how to put this. The defendant has these pesky things called rights, of which you will need to
Your Honor, I understand there's no need for explanation. I'll withdraw my objection.
All right, proceed.
And just a point here, we did have the server leader as a witness, and that would have been a time where you could have asked questions about something like this. This is to point out my client's motives. This is October 15th, 2021. This was 4 days after we first started talking about the trial. October 11 is when we have our first instance of the judge saying, I will preside over the case. Here are the jurisdictions. I shared that earlier at the beginning of the trial. This is only 4 days. This was before the claims were made clear. It was several weeks later that we had to have a rehashing of what the charges were to be in the first place. So we have good reason to believe that my client was operating normally, not with any accord to the claims of the courts, as they weren't decided, the evidence wasn't submitted, etc. So this is an example of someone higher up in the staff congratulating Master Oogway on making a good decision for the server. This was someone who was banned because they were a Nazi. I present it to the jury to show that Master Oogway has some sense of duty to the server, such that he tries to protect it. This, to me, shows a motive of preserving the server in good faith, and would be counter evidence to the motive that he's trying to destroy it or harm other people in the server. This also goes, it is sympathetic to my view that he is joking when he is making claims about destroying the server, given the kinds of jokes he makes. And this is evidence of his genuine feelings about the server. He's trying to do a good job. This is reinforced by an admin congratulating Master Oogway for doing a good job.
Objection, Your Honor.
You can let me know what the objection's about as you object.
Conjecture, Your Honor. Speculation. speculating the motives of the client during an action?
May I respond before you?
You may before I rule.
So the only reason why I am talking about the speculation of motive is because motive is being speculated as part of your claim. I feel it is right for me to respond to such speculation and conjecture. I am providing evidence of such, so it is not mere speculation. We are making an induction here.
I'm going to sustain the objection. However, defense counsel, perhaps you could rephrase as a question, perhaps of the jury. Either now or in your closing statement. I'll defer to you.
I'll possibly do both. So I just asked the jury to consider if someone were truly trying to sabotage the server, why would they try to fulfill their duties as a good moderator? And if they were truly sabotaging the server and harming others in the server, why would the admin be congratulating them on doing a good job? I leave it to the jury to ponder that question. So the next part of what I would like to do is to go through the evidence. So part of the evidence that was brought up is about the possibility or impossibility of being a turtle. And specifically, one piece of evidence that the prosecution thinks is damning is the line where Master Oogway says, "humans other than me," implying that he himself is a human. I'd like to offer a plausible alternative that is reasonable. Saying "other than me" does not imply that they are of the same kind. He could be just talking about the kinds of people who can have, or the kinds of entities who can have conversations, meaning those able to commit a conversation, to discuss things other than me, and he knows that the other people in part of that would be humans. Not an admission or an implication that Oogway is himself a human, just that he knows his audience is human. The other thing I'd like to point out is the prosecution brought up the anatomy of a turtle. While it was quite enlightening, there is no evidence of my client's anatomy to compare that to. As such, without evidence of my client's anatomy, any evidence of another animal is inert. The description of a turtle has no implication on the kind of anatomy of my client as evidence. A tortoise having a shell does not demonstrate that Master Oogway is not a tortoise. I don't see the relevance of that evidence. I asked the jury to think about why that would be relevant to the court. Now, the next part of the evidence that was brought up was impossible to meet the criteria of being a fictional tortoise. I believe the prosecution contradicted themselves here. The prosecution said that a tortoise is patient, kind, altruistic, and intelligent, yet cited Mitch McConnell as a tortoise. It is widely believed Mitch McConnell is malicious and not kind, not patient or altruistic. He is intelligent, though. And so I ask, if Mitch McConnell is a tortoise, which was admitted by the prosecution itself, why can Master Oogway not be a tortoise just because he's not patient, kind, or altruistic? It seems to me that if a malicious tortoise can be Mitch McConnell, then a malicious Oogway could be a tortoise as well.
What's the objection?
I in fact addressed this particular point during my presentation of evidence, where I said that he also did not meet the particular criteria necessary for him to be qualified as an individual who could be considered akin to an evil tortoise.
I think the defense is addressing that right now. They can proceed.
Yes. You made the claim that Master Oogway could not be an evil tortoise, yet you are claiming he is malicious and trying to start a cult and overthrow the stone. That to me seems like evil behavior. So either you contradict the notion that Master Oogway can't be a tortoise, or you contradict the notion that he's not malicious. Either way, the contradictions seem to fail on the account that he cannot be a fictional tortoise. It seems to me that if Mitch McConnell can be a tortoise, And if Master Oogway is biologically human, he can be a tortoise as well, since Mitch McConnell is biologically human. So the question for the jury is, given the prosecution's commitments, why can't Master Oogway be a turtle if Mitch McConnell can be a turtle? What is it about tortoises that mean their human manifestation has to be like Mitch and can't be like something else? So some other points about the biology. I mentioned this earlier. There's been no argument that the biology demonstrates the identity from the prosecution. Merely the claims made by the prosecution are assuming that to be the case. There's also the additional presupposition that identity is singular, and then there cannot be a pluralism of identities. I would like an argument that there can't be a pluralism of identities from prosecution. And furthermore, there has not been any demonstrations of the two claims that I think are necessary for this court case to go through. One is the sovereignty of identity, and the other is rhetorical sovereignty. Those have not been addressed by the prosecution. My client is the expert of their own identity. It needs to be demonstrated that he is not the expert of his own identity. It also needs to be demonstrated that when he makes a claim about his identity repeatedly, which we saw in the evidence, we saw over and over again, Master Oogway said, I am a tortoise, I am a tortoise, I am a turtle. Over and over again, talking about that. More evidence of that than saying they were human. The only evidence of saying they were human was an implication, which I provided a plausible account. All the evidence there presented is Master Oogway, who has the authority of his own sovereignty and identity, claiming, I am a tortoise. On what grounds are you rejecting the sovereignty of Master Oogway's identity? That has to be addressed. The rhetorical sovereignty needs to be addressed. Furthermore, it needs to be demonstrated that the court has the jurisdiction over my client's identity, given there's been no psychological assessment, there's been no biological assessment, there's no evidence about any of these things we're assuming for the client. So we have to go with the strongest evidence, which is the identity presented by my client. It's simple. My client is a turtle because he says he's a turtle. That has to be shown that it can't be correct. And it has not been demonstrated by the prosecution. None of the evidence here today is relevant to that. And we've talked about how the motive is not demonstrated as well, given that words are not literal. So I'd like to point out one last thing in the evidence. The evidence is presupposing a foundational semantics, which is not warranted or used in our natural language. They are saying things are literal. For example, when talking about a fruitcake, assuming that Master Oogway was literally calling themselves a fruitcake. This is not something that most of us believe. For example, I brought up with the witness Stone about spill the beans. There are other examples too, like pitch being high or low. It's neither high nor low. We're using that as a metaphor. So I see no reason why we should rely on this kind of foundational literal semantics that the evidence is relying on. As such, I don't think we should read the evidence in the way the prosecution is presenting it. I think a better explanation for some of these pieces of evidence is that they're jokes taken out of context. The motives of my client are better demonstrated by their actions, which is their duty to the server, trying to protect it, to take care of it, to be a good moderator. The jokes that they say as quips are not evidence of their motives, or they're not better evidence of their motives than their actions.
Do we have witnesses to call? I fear that we're engaging in a bit more argumentation than we were looking for here. Are we ready to start calling witnesses?
I was under the impression this was the time that I addressed the evidence presented.
It would be time for you to present evidence, or to present evidence in the light that you would want. I would just not want you to pontificate on content better reserved for, say, a closing argument, if that makes sense.
Yeah, understood. My goal here is just to address the evidence as presented by the prosecution. And provide plausible explanations, better ways of interpreting it, and to present the standards that the evidence are not meeting and that should be met in order for this trial to go through.
I object to the use of the word "better" ways of interpretation.
On what grounds?
What on? Yeah, yes. On what grounds?
Like begging the question. I feel like that alternative methods of interpreting the information would be a more apt statement than better. Better implies that the way in which I've presented the evidence myself is inferior to the way in which the defense is presenting the evidence. I do not feel that has been demonstratedly or made demonstrably clear.
Well, I don't think that objecting on the grounds of question begging is
an actual objection.
I don't think it's a valid objection. But the court will note for the record that it's clear the prosecution has one manner in which it is presenting the evidence in a particular light, and that the defense has an alternative view of that evidence, and they are presenting it in a different light.
It seems
in reference to that.
It seems to me straightforwardly true that both sides would be presenting the evidence as they see is the best read of the evidence. Since you are making the
court
claim,
concurs, so we can move off of this now.
Okay, great. I lost my momentum. One moment, Your Honor. Another piece of evidence that was brought up is that Master Oogway wanted some comments to be deleted. For example, Ratty's comment about being a Nazi, turtles being a Nazi. If you were a turtle and you were called a Nazi based on your identity, that would be something alike hate speech. And it seems reasonable to me that wanting to delete something like hate speech would not demonstrate a malicious motive. Instead, it would be a type of personal safeguarding, trying to protect his own personal sovereignty. And when we talk about deleting, in the case of the turtle there, and the turtle aesthetics, etc., it seems to me like we're already granting the premise that my client is a turtle. So just to point out all of the things that we went through sort of in brief, there are a few things that the evidence needs to demonstrate, but it fails to demonstrate. One is biological essentialism as it's related to identity. Two, you need to show the biology of my client, not just tell me a podcast about turtles biology. Three, you need to show that identity cannot be pluralistic. It must be one identity, which relates to the biological identity. Four, you need to demonstrate why we can't take those as jokes. And five, you need to demonstrate that my client is identity confused. Seems to me a tall order given my client is the expert on their own identity, and they were quite consistent in the evidence of claiming they were a turtle repeatedly. The one piece of evidence you tried to use regarding negating that was about fictional tortoises. It can't even be a fictional tortoise, yet you grant that Mitch McConnell can be a tortoise, and you haven't demonstrated why it must be like Mitch McConnell in order to be a fictional tortoise, why there can't be other attributes that wasn't demonstrated by the evidence. So, in short, there's been no case demonstrated by the prosecution in order for the claims to go through. That's all the evidence I have at this time. And the witness I was going to call, Dave the Dastard, was not able to be here today. Dave was in peak exhaustion after completing a very, very thorough writing. So they were not able to be here today. But I have been able to share some of Dave's expertise in my opening and closing statements.
All right. So, yes, I presume you don't mean your actual closing statement for the court here.
That's right. Yes,
but in your examination and admissions to evidence and reviewing the evidence as well. Right. So, with that being said, with no further witnesses, it's time to move into closing statements. counsel, I would really like to not hear any objections here. This is your time to make your case, beginning with the prosecution and then the defense. We should respect each other's time here with these closing statements. I will follow these statements with instructions for the jury, reminding them of the instructions once more, and then we will proceed with the jury vote as they deliberate. So it is on you, Coco, as prosecutor. Go ahead and submit.
Points of clarity. Could we establish a standard of objections given something is sufficiently egregious that might be possible for these closing statements?
If there is something that would cause a significant disorder in the court, I will call for order. Shy of that, the prosecution here has laid out their evidence as you have in the defense. Their closing arguments should be bringing that all together in a way that reminds the jury of what they're here to vote on. We have to leave this to the jury's discretion at this point. Prosecution and defense attorneys alike may be a bit more argumentative directly in this stage. They may deploy their rhetorical tools and such to make this a memorable closing statement. That's not objectionable. We're going to allow these statements to go through pretty much as they would. So there's not really a place here for objecting to a closing statement. It's not testimony. It's not evidence. It's not. There's not really something here to do with that. So with that being said, a prosecution, you may proceed.
Thank you, Your Honor. I believe that the prosecution has made ample case that there are clear and present motives in the behaviors of Master Oogway in whether or not it is practical or not, or considered to be practical or not by the Honorable Stone. There are implications and a clear and present motive that the defendant's client does, in fact, have intentions or a desire to take over the server, and also is clear in their desire to not be held to account for the actions and transgressions that they have during the course of their activity on the server. I also believe that while the defense has made several good and interesting points, they are focusing on trivial rhetoric that is not necessarily entirely pertinent to the discussion that we are focusing on having, bringing up the idea that species essentialism is necessary in order for us to establish whether or not the defendant is in fact claiming, or whether or not we can in fact qualify that the defendant is claiming to be a tortoise or a turtle is necessarily irrelevant, in the same way that it would be necessarily irrelevant if an individual was attempting to use gender as a way to obfuscate the consequences of their own individual actions, as the idea that one can identify as numerous things does not necessarily go against...
This court is a sham. You have no right to rule. All power to the people.
Order. Good have to mute Mark's billion.
You may proceed. The jury is to ignore this outburst.
Thank you, Your Honor. And Honorable Bailiff Stone, you keep a very orderly and efficient court. I apologize. Yes, so in the same way that gender would necessarily be a way, or a gender could be used as an identity to attempt to obfuscate one from the accountability of their particular actions, the defense is attempting to employ a similar ideal to defend or protect themselves from the consequences of their own individual actions. As the evidence suggests, Oogway does in fact claim literally to be a number of things, and does claim in fact to literally be a tortoise. I believe that the evidence has been made clear that it is in fact biologically impossible for the defendant to in fact be a tortoise, and if they were in fact not a tortoise, they would be held to account for their actions as any human being ought to be. and that the presentation of the fictional tortoise portrayals, it was made clear during that particular bit of evidence that Mitch McConnell is in fact a bot in the simulation of our lives that we are all experiencing. So to claim that Oogway would in fact have to meet all of the criteria in order to be considered a tortoise or not a tortoise was necessarily irrelevant. The claim was that he meets neither the good or the implied bad criteria in order to fulfill the role of being a fictional tortoise or even being a tortoise in form of metaphor. There are numerous instances in which Oogway does not display the characteristics of either an evil tortoise, such as Mitch McConnell, or a benign or altruistic tortoise. In the case of perhaps Master Oogway, who he is attempting to claim himself to be, and on the grounds that the defense is creating a sham of a case in the attempt to further obfuscate their client from the consequences of their actions as a human, and claim that they just identify as a tortoise, holds no ground, holds no water, and holds no lettuce.
All right.
That concludes my closing statements.
All right. The prosecution is rested. It is on the defense.
Thank you, Your Honor. Thank you to the jury for being here today. I hope they provided you with a nice lunch. And thank you to all the witnesses who came up. So let me remind the jury of the claims on the table. 1, Master Oogway misrepresented himself. And 2, that fraud was done incorrectly to identify as a turtle. Those are the claims. The motive is a speculation for why they might incorrectly identify as a turtle, but the motive is irrelevant to the fact of if they did or did not correctly identify or fraudulently misrepresent themselves. There can be any number of motives there that are compatible with genuinely identifying as a turtle. It could be the case that Master Oogway is in fact a turtle and has that motive too. So the motive has no force on the claims on the table, which are the fraudulent misrepresentation and that fraud being of a turtle kind. So I'd like to reiterate what I think needs to be demonstrated by the prosecution in order for us to determine that my client misrepresented themselves. 1, it must be shown that there is no sovereign identity here, that Master Oogway cannot be the expert of their own identity. None of the evidence submitted supports that fact. The only thing that came close was an expert affidavit from Frozen Broccoli, where Frozen Broccoli mentioned that they are a biologist, they have all of the credentials necessary for biology. There is no biological way for a biological turtle to engage in what Master Oogway is able to engage with, yet there was nothing about identity presented there. This is where the biological essentialism as it relates to identity is crucial. The prosecution needs to make the case that biological essentialism is necessary for the identity. That was not demonstrated. There was no evidence presenting biological identity, biological essentialism then creates the identity. So, given that fact, identity is a subjective experience. The subject is the expert of that identity. The only expert in this case that matters is Master Oogway. The evidence over and over again showed a consistent utterance of, I am a tortoise, I am a turtle, over and over again. Given they are the expert, given there was no refutation of sovereign identity, we should rely on Master Oogway's evidence here, Oogway's claims, over this slapdash, haphazard, inert evidence presented. So let me just point out some of the rhetoric the prosecution used and why it's inert. They mentioned there were clear and present motives. As I already stated, the motives are inert to this case. The motives don't matter to the fraudulent representation or not. Master Oogway could have had those exact motives and still correctly represented themselves. We talked about Stone saying that it wasn't considered practical at this point, and because it wasn't considered practical at this point, it's probably a joke. And since it's probably a joke, we can't rule out that there's some kernel of truth there that Master Oogway wants to take over. But what evidence? There was no evidence presented outside of this speculation. It was just claimed. The prosecution just claimed clear and present motives. And then we're relying on Stone's feelings about jokes? What if Stone is incorrect about the joke? What if Master Oogway was joking and Stone misread it? In fact, Stone even admitted it's a joke with a small kernel of truth. That's our best piece of evidence for the motive, and the motive doesn't even have inertia to the claims. On what grounds does the prosecution have the ability to claim this? I ask the jury to seriously consider that. It's clear to be held accountable for what? On what evidence? Master Oogway is trying to get out of what? He's not in any danger. He's doing a great job as a mod. As the evidence I presented, we have an admin congratulating Master Oogway. The best explanation for the types of rhetoric Master Oogway is engaging in here is that they're jokes. Also, the prosecution relied on this foundational semantics that literally must mean literally. But I take it that the jury has experienced this where sometimes people will say literally, ironically, to be an emotional amplifier. In the same way that we might say fucking to make it more extreme, not to talk about literal fucking. Language is not always literal. The prosecution has to rely on this literal foundation semantics in order for their claims about Master Oogway to be taken into context. And so the prosecution tried to say, I'm focusing on trivial rhetoric. But what's the evidence for that? The prosecution did not share any evidence for that. They just made the claim, I'm relying on trivial rhetoric. Then they said something about species essentialism is necessary. The defendant is claiming to be a tortoise is necessarily irrelevant in the same way someone using gender is necessarily irrelevant. But on what grounds? Why is it necessarily irrelevant? They made the claim with no evidence. They made the claim with no reason why. They just made the claim. And so I want to point out again, the standard that needs to be made here. The sovereign identity has to be refuted, and it wasn't refuted. Nothing was stated about that fact. And then the claim was made that the defense was making the same kind of claim that Master Oogway is, which is to protect ourselves from literally dozens of things. I don't see any evidence for that. The biology of the tortoise is not evidence for the biology of Master Oogway. There was no evidence submitted there. The fictional tortoise is in fact a bot was something that the prosecution rightly corrected. I did point to biology, but unfortunately for the prosecution, this is still damning. The prosecution believes we are in a simulation. They stated it outright. Mitch McConnell is a bot in the simulation we all live in. Well, if we are in a simulation, and I ask the jury to consider this seriously, if we are in a simulation, then what the hell does biology have to do with identity? Biological essentialism is necessary for identity in this case in order for us to demonstrate that Master Oogway is not a tortoise. The prosecution believes we're in a simulation. There's no grounds for biology being necessary then. Because in a simulation, it's possible that biology has nothing to do with it, and instead we're in this hyper-real fiction about biology. So it seems to me that no evidence was presented that concretely, beyond a reasonable doubt, demonstrated my client is not a tortoise. And in fact, the evidence presented showed that my client represented themselves consistently as a tortoise. Mitch McConnell can be a tortoise. Master Oogway can be a tortoise. There's no biology pointing out to Master Oogway. Nothing was shared by the evidence. There's no evidence of the biology there. So all we can really do is rely on the identity of my client. which was consistent. Sovereign identity was not refuted. Sovereign rhetoric was not refuted. And there wasn't even a case made for the court having the jurisdiction in the first place. Now, let me point out a very pertinent piece of information for precedent here. And jury, I want to highlight this with great care. Your decision today will decide how future court cases in Arthuria are managed for centuries. What you decide today will impact millions of people and animals. If we decide, the court has the ability to decide against the sovereignty of an individual, their identity, then we've created an authoritarian court. This would violate not only the truth we try to seek in Arthuria, it would also violate Discord community guidelines. This would violate the rights of my client to decide in their own way, in their own place, their own identity. They are the sovereign of their identity. They are the sovereign of their rhetoric. My client can address themselves as they please. The court cannot decide that. My client can identify as they please. The court cannot decide that. There was no evidence presented for why we should grant my client should not have that ability. There was no evidence presented for my client having one identity and then lying about a different one. My client was consistent. The evidence is consistent. The prosecution merely made claims without evidence, speculated, and they're creating a situation where we're going to create an authoritarian court. So I ask the jury, do not take this vote lightly. You are deciding the lives of not just my client's identity, but everyone's identity in this server. Ask yourself if you want the court to be able to decide that you're wrong about who you are. That to me seems like an utter violation of your rights, of my client's rights. And as such, this case should be dead on arrival. And so I leave it in your reasonable hands. Please, please consider the sovereignty of my client, their identity as a turtle. Thank you.
All right. With the defense resting their case, it's time to remind the jury of your job today. It's a sacred duty, a sacred responsibility. You are to deliberate, look over this evidence, think back to the arguments that counsel has presented, and come to a reasonable determination of your opinion given this evidence. There are two criteria that need to be met to establish the particular crime in question. One, that the defendant, Master Oogway, fraudulently represented himself, and two, that the nature of the defendant's fraudulent representation was that of a Galapagos tortoise. If these two things are not met, in your opinion, you should vote not guilty. If you believe that they are met, you should vote guilty. At this point, you have heard both cases, you have heard the evidence, and you are to vote to a standard based upon the preponderance of this evidence, meaning that you should exercise your best judgment in light of everything presented and come to your own conclusion accordingly. This court will take a 2/3 majority, rounding down to the nearest jury vote to determine guilt. This is done for several reasons, but suffice to say, both defense and prosecution have agreed to the standard of the vote. As such, this is what we are moving forward with. So with that being said, Stone, if you could show the jury to their poll to deliberate, we can go ahead and remove gags on any jury members, which I'll go ahead and do. And we can go ahead and put this to a vote. If we do have a guilty verdict, then we will proceed with sentencing in either a follow-up hearing or immediately following the verdict coming back here. I see that we have 1, 2, 3, 4, 5, 6 potential jurors. So, with that being said, let's go ahead, Stone.
Absolutely, Your Honor. To the jury, the poll is going to be posted in Siri Saloon. You can find it there. And thank you, everyone. Thank you to the jury for taking the time to witness this court session. And thank you to Mr. Whip and Mr. Licious for saying what they had to say. And of course, thank you to our mostly honorable Judge Walt Anderson for hosting.
Right.
Yeah, just noticing that nobody is voting in Sirius Saloon. So if the jurors could do that, just so we can get a conclusion on this, we'd appreciate it.
The prosecution, defense, and defendant cannot vote. Everyone verbal. Everyone else, other than the prosecution, other than counsel, the defendant, the judge, can vote. So you are a juror. It is a jury, quite literally, of your peers that decided to show up. That we're not making arguments or administering the case or administering the matters here in court. If you do not believe you can put a vote in good faith, then you do not need to vote.
Yeah, Your Honor, I am seeing votes starting to pile in, it seems. So would you like to officially conclude the session, or would you like to give it a bit longer?
I think based on the current jury vote, there's no reason to move any further at this point in time, given that we had 6 jurors present to vote. This court, upon seeing the current vote call, can call it right now. We, the people, here have identified that Master Oogway is to be found not guilty.
Thank you, Your Honor.
Thank you, Your Honor.
All right, this court is adjourned.
Yeah, I guess we're out of this bitch.
Thank you, Your Honor.
Well, nothing about sentencing now, I think, because now we have a very innocent man. So he'll just, or turtle, or tortoise, or fruitcake. Well, he's truly innocent of this charge as far as the jury is concerned.
GG.
Oh my god, he's gonna bring me back in court with what he's saying.
Makes me want tacos.
Alright, well, I played the Law and Order theme, and for some reason Ice Cube started playing.
Yeah.